Welcome, everybody. My name is Tracy Philippi. I am the president of the Friends of the Cottage Grove Library. We're so happy to see so many of you here at our first event, Legacy Planning with Peter Osman. This is the first of 5 events that the Friends are hosting in 2022. So if you haven't already, I really encourage you to visit our website and see what else we have planned. There really is something for everybody in our community, so we're very excited about that. Our next event is on April 23rd. It's an Earth Day event that's taking place in the Norman Vieth School Forest, and it's going to be a great time. So with that, I'm going to go ahead and introduce our moderator, Allison Weber. Allison works in marketing communications and grew up in Cottage Grove. She now volunteers on the marketing committee of the Friends of the Cottage Grove Library and lives in Cottage Grove with her husband, first grader, preschool, and their dog. So Allison, take it away.
Thanks, Tracy. I'm really excited to be here and help facilitate the first of this season's events put on by Friends of the Cottage Grove Library. And I just have a couple quick housekeeping events before we get started here. If you could please make sure your cameras are off and your microphones are muted, that would be excellent. The session will also be recorded for future viewing, and so we'll send out a link for access to that after, I think tomorrow, the link will go out. And then as we listen and learn today, please feel free to type in questions in the chat box, and I'll help field those questions and have Peter address them after his presentation portion of the webinar. And thanks for everyone who already sent in their questions. And then we'll also be emailing a post-survey interview or post-event survey throughout for your thoughts about the event and to see what other types of events you'd be interested in attending. So without further ado, I'll introduce today's presenter. Attorney Peter Osman is a graduate of not only Monona Grove, but UW Law School. His practice is focused in the areas of estate planning and elder planning. So without further ado, I'll turn it over to Peter.
And appreciate the invitation to be able to speak and present here today. I do want to emphasize what Allison shared there. Please, if you do have questions, feel free to type them in the chat, and we'll try to carve out as much time as possible to address those towards the end of the presentation. My goal is to present for about 30 minutes, maybe 40 on the high end, and then from there field questions. Make sure we're addressing the things that are important to all of you. So from there, I'm gonna share my screen here so that you can all see the PowerPoint and kind of follow along. So give me one moment while I do that. All right, so we're going to go ahead and start the slideshow here. Allison or Tracy, let me know if for any reason this isn't showing up correctly on your end. But hopefully this is showing the PowerPoint here. So initially, just want to kind of touch on what we want to go over here today. And after getting through the standard legal disclaimer stuff, here, where I like to start when we talk about estate planning from an overview perspective is to focus on what are in our minds, the 3 phases of estate planning. And to me, this really gets into what does every person or every family need to make sure they're addressing when they're thinking about their estate planning. We'll take time to get into terminology and some definitions here today during the presentation. But in my mind, there are really 3 primary areas of concern or phases of estate planning. The first being incapacity planning. This is sort of your lifetime planning. What happens if you're incapacitated, if you can't make decisions for yourself? Who have you appointed to make those decisions? And how have you directed them? The second phase of estate planning in our minds is asset transfer planning. Some might argue this is just a friendlier way of saying death planning, which isn't totally untrue. But the reason we label it this way is because we're really focused on helping clients understand how do assets transfer when a person passes away? How does what I own get to the people that I need and want it to be distributed to in the event that I were to pass away. And then finally, inheritance planning. Inheritance planning is really just making sure that after I've passed away, whoever I've left the assets to, what concerns do they have? What controls do I want in place? What restrictions or protections can I put in place to make sure that the assets that are inherited are managed appropriately and that my wishes are met. From there, I'll start by jumping into some of the, again, initial phases here as we talk through estate planning. The first phase of estate planning, as I referenced, is incapacity planning. And to me, in a lot of ways, this is sort of the easiest to understand phase. And it's also the phase that's relevant for every single adult 18 or older, whether I have a substantive estate or not. And regardless of what I do or don't own, it's possible I could reach a point in time during my lifetime where I can't make decisions for myself. And so incapacity planning is highly focused on making sure that if I can't make my own medical decisions and if I can't make my own financial decisions, that I've appointed somebody else to make those decisions, and that I've given them the appropriate directions and powers to be able to make decisions. And so from that perspective, segregating the decision making out, on the medical side, the primary document is going to be the healthcare power of attorney. Healthcare power of attorney is a document that outlines who can make medical decisions for me, and specifically what decisions should they or can they make. From that perspective, what's important to understand is that anytime you have a power of attorney dynamic, that's me as an individual appointing somebody else to make decisions for me and empowering them to make decisions that are in my best interest. So when I'm selecting a decision maker under a power of attorney, in this case, we're talking specifically about a medical decision maker under a healthcare power of attorney, I'm giving them the power to make decisions. I may be limiting what powers they have or what decisions they are able to make. And I'm then giving them my directions as to preferences, especially with regards to medical care. So we're going to touch on issues here when drafting this document to make sure that I've made my wishes known regarding end of life situations and the use of feeding tubes or breathing machines or other life sustaining procedures. And that I've indicated my preferences relative to my own medical care, because the person making the decisions should be making the same decisions I would have made had I been able to make those decisions. So this isn't me appointing somebody to do whatever they want. This is ideally appointing somebody to make the same decisions I would have made. That healthcare power of attorney is supplemented by a couple of other medical documents, the first of which is a living will or directive to physicians. This is a document that's focused directly on what my end of life wishes are, specifying in 3 specific scenarios specific to the state of Wisconsin and how our medical practices operate here, understanding what my wishes would be in a persistent vegetative state, or if I have a terminal condition where death is imminent. So again, that's going to supplement the medical power of attorney. And then the HIPAA authorization is dealing with our HIPAA privacy laws, which otherwise might restrict who can access information. So this isn't a decision-making document. This is who can information be shared with, and who can the doctors and medical providers speak directly with. The other side of decision-making during a potential incapacity is with regards to financial decisions. And you'll see here what's called the durable power of attorney. It's often referred to as a financial power of attorney, and that is one of the primary focuses of the document, is to make sure that financial decisions can be made on my behalf. But it really covers all non-medical decision-making. So anything that's not a healthcare or medical decision is going to be covered by that durable power of attorney. So this is the person running my day-to-day life, paying bills on my behalf, making sure that all of my affairs continue on and that my life continues to operate from a functional perspective despite my incapacity. Any of these power of attorney documents or incapacity documents are going to apply both during a temporary or in a potential permanent incapacity situation. And again, as I alluded to on the front end, these are going to be documents that's relevant to anybody age 18 or older. We actually have a lot of clients who not only like to do this for themselves, but as their kids reach the age of 18 and go off to college, making sure their kids have these documents in place so that if a decision needs to be made, if there's some kind of an accident while their child's away at school, they have the appropriate decision-making powers and authorities. One final point I'll leave us on the incapacity side. A question we often get is, why would I do these documents, or what's the need for these documents? Well, the need is really to replace what otherwise would take place if an incapacity occurred and these documents weren't executed. What would happen instead then is there would be a guardianship proceeding, an adult guardianship proceeding, and a court would have to intervene in order to appoint somebody to make these decisions and grant that person those powers that the court decides to permit the person to have. So I always think it's important to think about, well, what's the alternative if I don't do this? Well, if I don't do this, that means all of my decision making is going to be subject to a court selecting somebody. So I've lost control over who is going to be selected. The court's going to decide what powers they do and don't have. So I've lost the ability to direct that person in terms of their powers. And finally, I've put my family through having to deal with the courts in an emergency context, in a context where I have no longer, I can no longer make decisions and they need to get somebody appointed immediately. So these relatively straightforward documents are used to avoid that scenario. Moving on to what we refer to as that second phase of estate planning, which is asset transfer planning. We're going to talk about two different documents here. We're going to talk about the use of a last will and testament, and we're going to talk about the use of a living trust. And we're going to draw some distinguishing features between them, talk about what is similar between the documents and what's different about the documents. Now, before I get specifically into those documents, I do want to pause momentarily and acknowledge again, what happens if I don't have these documents in place? Well, the reality is, and one of the things we often ask, you know, if we were in a live presentation and with an audience here, I might survey the crowd and say, how many of you have an estate plan in place? And a handful of individuals would raise their hands. I typically then make the point that actually everybody has an estate plan in place. It's really just a matter of whether you've drafted it or customized your estate plan, because the state of Wisconsin has drafted a default will for every person over the age of 18 who hasn't drafted their own. It's contained in the Wisconsin statutes, and it's what attorneys will refer to as intestate succession. In other words, what's the default distribution of assets in the event a person doesn't draft their own will, which is unfortunately a substantial portion of the adult population that hasn't drafted their own estate planning documents. And so the state of Wisconsin has a default will if I don't draft one for myself. When we talk about documents you can use in the asset transfer phase, again, the concept of a last will and testament is the first piece we'll talk about. A last will and testament is what I often describe as a reactive estate planning document. And the reason I describe it that way is because it's a document that I might draft during my lifetime, but it's not going to have any relevance until after I pass away. In other words, it is going to react to the assets that I own at the time that I pass away and outline and guide the distribution of those assets in the post-death context. If I get a little bit more legal technical here, a will specifically reacts to the assets that become a part of a person's probate estate when they pass away. And it's important to understand how an asset becomes a part of someone's probate estate, and therefore understand how a will does or doesn't direct or guide the distribution of an asset. So when a person owns an asset and passes away, that asset is going to become a part of their probate estate, and that's going to trigger the relevance of a will. Now, what is a will going to do in terms of distributing assets or authorizing the administration of my estate, well, the will is going to appoint some people in some important roles. The will is going to appoint a personal representative or an executor. That's the person responsible for carrying out the terms of the will. That's the person responsible for ensuring that the will, as it's admitted to the probate process, which we'll talk about in a moment, is carried out according to the individual's wishes. And so the personal representative or executor is the nominated person who works with the court to administer the terms of the will. A beneficiary under a will is going to be exactly what it sounds like, a person or persons who receive the benefit of the assets that are distributed through the probate process and through the estate. And then a guardian is going to be a person who's nominated to serve as a caretaker or a backup parent, as some people will refer to it, for any minor children. So a guardian's nominated if you're someone like myself who has minor children, need a caretaker, need a legal guardian if they're under the age of 18. And so we use the will and the estate planning conversation to nominate who those guardians will be. And towards the end of the presentation here, I'll talk a little bit more specifically about guardianship and what goes into that decision-making process. You'll also see I refer here to what's called a trustee or a testamentary trustee. This is a reference, and again, taking myself as an example, if I were drafting a will and I had minor children or even adult children who I thought were too young to be able to manage their inheritance themselves and would need somebody to manage that inheritance for their benefit or control the access to the funds, then I might appoint somebody as a trustee for that beneficiary, with the trustee being the person who controls and manages the inheritance, but for the direct benefit of the beneficiary. Now you see I use that term testamentary in the parentheses there. That's just in a recognition to the fact that in this context, we're talking about a trustee who's appointed in a post-death context. In other words, is appointed after the will is administered. This is not a lifetime trustee, which we'll talk a little bit more about as we transition into some of the other conversations here. But again, high level, what does the will do? Well, in really simple terms, it does what most people commonly understand it to, is it directs the distribution of my assets, and it outlines how my assets are administered and distributed for the benefit of those beneficiaries. What we want to spend a little bit of time talking about now is again, what is that process that it goes through? I referred to the fact that the will only controls the assets of a person's probate estate, and that brings into play this term that is often discussed in the estate planning world, not necessarily always fully understood when it applies and why it applies. But specifically, the way I typically describe a probate initially is that a probate is the court-governed process of administering a person's estate. So when you hear a reference to probate, you understand that that means this is a court proceeding that's opened in order to administer a person's will, or if they don't have a will, in order to administer their default or intestate estate. Common misconception, probably one of the most common misconceptions that we hear when we're meeting with clients, is if I have a will, my estate doesn't go through probate. Not only is that misconception inaccurate, it's actually fundamentally flawed, because a will can only govern those assets that become subject to the probate court administration. So if a person is drafting a will, they know inherently that that will is going to govern assets through this probate process. They're going to work through the court in the county where the person passes away to administer the estate. And so it's important to understand that a will is directly connected to the concept of probate. And if a client is using a will, they're not doing anything with that document to eliminate or avoid that process. Now, one of the most common things we get from a client or a set of clients on the front end when we meet with them and ask them about their goals, they'll often refer to wanting to avoid or eliminate probate. And one of the first things I'll ask them back is, why do you want to avoid probate? Now, probably the most common answer is, I don't know. I've just heard it was bad, which is fine. And certainly reflects some of the conversation about the probate process in the public sphere. But I do think it's important to understand, well, why would we want to avoid it, or what are we avoiding? To me, it comes down to 3 or 4 points here. When people go through a probate post-death, if somebody's family member, parent, sibling passes away and they're subject to this probate process, we've kind of tracked what do people complain about when they go through this process. And despite the fact that, you know, none of what's on the screen necessarily looks appealing or attractive when you just go through each item, probably the biggest complaint or biggest surprise we hear from individuals going through the probate process is that it's a public process. It's a public court proceeding, just like any other court proceeding. And so what that means is that at the time that the probate is begun, everything that happens with regards to that post-death administration is a matter of public record. This means the court has record of it. I could go down to the courthouse if I really wanted to, or if anyone even knows where the courthouse is anymore, and request copies of information relative to the will, the beneficiaries, contact information, size of the estate, and who's inheriting the assets under the estate. Now, more commonly, as some of you might be familiar with, all of that same information is available on the Circuit Court Access page, or sometimes referred to as CCAP, meaning this information isn't just public, it's publicly available online. So anybody with a computer and internet access can see what I owned, who's receiving that money, how to get a hold of those individuals. It's a lot of information in the public sphere, which is uncomfortable to some, and for some clients concerning in terms of what can be done with that information if the wrong person gets a hold of that information. It'll also tie into the last point that I'll talk about in a moment, which is the sort of pseudo democracy, because of the individuals or persons who can get involved in a probate in the event that one is triggered post-death. Two more, or two other areas that we hear clients complain about or get frustrated with in the probate process: the time that it takes post-death to administer the estate and complete the probate process, and the cost that is incurred in going through the probate process. So again, not atypical for the court to set a deadline of 12 to 18 months from the date the probate is opened in order to close that probate. That can be a long time for beneficiaries to wait post-death relative to an inheritance. And frankly, it can just be a long time for the executor or personal representative to have to be dealing with all of this after a person passes away. And obviously, something that's going to cause complaints when you have people inheriting money, the cost of a probate can be a frustrating factor for the individuals involved. On average in Wisconsin, you see about 4 to 8% of the estate being spent in the probate process. Now, that's not just paid directly to the court, and it's not actually measured as a percentage. This is just a way we've developed of tracking what's the impact when an estate goes through probate. On average, this is going to be divided amongst court fees, transfer fees associated with the assets, and then also attorney's fees if an attorney is hired and gets involved to assist the executor or personal representative in carrying out the probate and carrying out their responsibilities. Now, when we talk about a pseudo democracy, what are we really talking about here? Well, what we're talking about is that the probate, because of its public nature and the statutory requirements, involves potentially a bunch of people we were trying to not involve in the probate process or in the post-death administration process, because the statutes define a class of what we call interested persons. This is going to be the beneficiaries that I name under the will. This is going to be the creditors of the estate. This is going to be any statutory heir, so that default will that I talked about. If there's somebody who would have inherited by default but isn't inheriting under my will, they're still an interested person. They still have a voice in the probate proceeding. Potentially a beneficiary spouse, potentially an ex-spouse of mine if I pass away and have minor children. All of these persons are interested persons, and they all have a right to information about the probate, notices about the terms of the will and how the estate is being administered. And they have not only the ability, but a venue, because this probate process is already a court governed process, to challenge my will, to challenge my nominations, or to otherwise create problems for the personal representative and the beneficiary through the probate process. And so when we talk about it being public, sure, one side of that is, do I want this information to be publicly available? The other side of it is, who am I bringing into the administration of my estate that I potentially didn't want to have involved? And what is the probate process forcing in terms of dynamics between the people I did name to be involved and the people who otherwise become involved as qualifying as an interested person under the probate process? So when you think about all of this, these are just important factors to consider when you think about how your estate is administered and what type of planning is going to make the most sense for you. So transitioning to talk about the other type of document we discussed or referred to when it comes to asset transfer planning, many people have heard about the concept of a living trust or a revocable trust, or even just a reference to trusts in general. And either have a good grasp on what it is or just know that it's an alternative that's out there. So to me, the point of the next 5 to 10 minutes is really just to kind of simplify the concept of a trust and discuss why is it used or how is it applied within the estate planning dynamic. The simplest way to describe a trust, even though it's completely inaccurate from a legal technical perspective, but the way to conceptualize what a living trust is it's a legal document that replaces the will and authorizes a non-probate distribution of assets. So we'll sometimes refer to it as a will that avoids probate. Now that's an oversimplification and again, inaccurate, but a trust can be used by clients instead of a will to proactively plan for their estate and to eliminate the post-death probate process. So, understanding trust 101 here, the very simple bare bones pieces to make sure we have a grasp of is a trust is a legal document that creates an entity, and the purpose of that entity is to govern the control, administration, and user distribution of assets that are placed into that trust. And the way a trust does that for assets that are titled to the trust is it takes the rights typically associated with any given asset that we own, and it divides the rights of control and use into two different roles. So important roles to understand within a trust: a settlor or a grantor is just the person or persons who create the trust. A trustee is the person who gets to manage or control the assets of the trust pursuant to the directions that the settlor has laid out. And the beneficiary, just like under a will, the beneficiary is the person who gets to use the assets of the trust. So when you have these roles within a living trust, it's important to understand, if I'm drafting this document and if I'm putting assets into this trust, as we'll talk about in a moment, what does that mean based upon who I've appointed in some of these roles? Now, anyone who's looking at the screen has already seen the spoiler that when you first create a living trust, typically you are going to fill all three of those roles. Or if it's a married couple, husband and wife, or both partners are going to serve as settlors, trustees, and beneficiaries. And most importantly, you're going to be trustees and beneficiaries, meaning that even if there are assets that you own that are placed into this trust, you still control those assets and manage them for your own benefit. So in other words, just like you do today, if you own those assets individually, you're putting them into a trust, but retaining all of the rights pursuant to those assets and not involving any other party at this point. In the event that you have a life event like an incapacity or if you were to pass away, the trust is now going to have provisions, backup provisions to deal with who takes over in those roles of trustee and beneficiary in the event that something happens to you and or your spouse and you can no longer serve in those roles of trustee or beneficiary. So you'll see alluded to here the incapacity situation where you would still be the beneficiary because you're still alive, but you would name somebody else as the trustee. as a successor to you if you couldn't serve. Upon your passing, now we have to have successors for all of the roles. So who should serve as trustee and who are the beneficiaries in terms of, and thinking about classes of individuals like spouses, children, siblings, parents, charitable organizations, all of these could be the beneficiaries. And they're the ones who are going to receive the use or benefit of the assets. What's important to understand, and we'll play into some of what we talk about here in understanding the trust, is if you've passed away or you've become incapacitated, what you've done by proactively placing assets into the trust, you've eliminated probate because the ownership of those assets doesn't change. The ownership of the assets remains titled to the trust despite the fact that you've passed away, because you weren't the owner, the trust was. All of the change that happens when you have a living trust is internal to the document. So if you pass away, the trustee changes and the beneficiary changes, but the owner was the trust during lifetime and the owner remains the trust at my passing. And so what I've done now is eliminated the probate process because nothing becomes owned by my estate. Nothing was owned by me and I passed away. It was all owned by this trust. And the trust contains all the terms for the distribution and succession of those assets. Here, what we're doing is highlighting some of the potential benefits or some of the potential uses of a trust. And we won't take all afternoon to try to walk through all of the different scenarios and applications of a trust. But what we do here is highlight some of the benefits, some of the things that could be relevant to a person who's deciding, I might want to use this strategy. We talked about the fact that it avoids probate or eliminates that probate process. It can be an effective way to plan for minor beneficiaries, knowing that we can leverage the trust structure to appoint a different person to manage the assets for the benefit of that minor beneficiary, or maybe even expanding that class a little bit, your young adult beneficiaries, right? Your beneficiaries who are 21 and 25 and maybe have are no longer minors, but maybe not quite ready to manage an inheritance themselves. You can create guidelines to those trustees to tell them how to use the money and what to use the money for the benefit of the beneficiaries, and define the specific uses or purposes. Expanding from that again, without going into a lot of detail, the trust post-death can accomplish a lot of other purposes. It can protect assets in the event that my wife passes away and I were to get remarried. There can be structures and restrictions put in place so that those assets don't go to my new spouse. If my wife and I currently have a blended family with children from prior relationships, this can be an effective way to make sure we provide for each other's benefit, but also protect our respective children's future interest in our assets and property. We can stage out the distribution to your young adult beneficiaries over time, so they're not getting all one lump sum all at once. So a lot of different uses, and this is just sort of the tip of the iceberg when you think about the uses here. But that simple concept of being able to segregate the right of control and give it to the trustee, and the right of use and give that to the beneficiary, brings in a whole bunch of possibilities in terms of what we can do and how a trust can potentially provide benefit for a client who decides to use one. Now, really quick primer here, really important to hit on. With a trust, avoiding probate is not automatic. I alluded to it before, but to talk directly about it, the way that the assets get governed by the trust document is by affirmatively coordinating the ownership and the control of those assets with the trust. This is a process you'll often hear attorneys refer to as funding the trust. So if I have a home, or if I have bank accounts, or if I have investments, I need to retitle those out of mine and my wife's names and into the name of our trust. Again, while that may sound odd initially, it doesn't change anything about our use or access because we're the trustees and we're the beneficiaries. So even though our bank account is in the name of our trust, we write checks off of it the same way you ordinarily would. We can deposit funds, we can withdraw funds. our house is in our trust, but we can still sell the house if we want to. We still have the right to live in the house and use it because we're both trustees and beneficiaries of the trust. But again, it's incredibly important when you're going through this process and considering this strategy to make sure that we get the assets appropriately funded to the trust. Otherwise, it's not accomplishing one of the potential benefits of using the trust, which is avoiding probate. So it's great to have a trust if that's a strategy that makes a lot of sense, but you've also got to make sure the assets are coordinated with the trust. And for our clients, this is something we do with them, that we prepare the paperwork on the front end. It's not like we just draft the trust and send them on their way and say good luck. This is our opportunity to make sure the assets that they have get into the trust appropriately. The last section I'm going to touch on before we open it up for questions here with time that we have is the post-death side of this, the inheritance planning. In the event that my wife and I both passed away, what do we need to think about? What do we need to discuss and design in our estate plan to plan for the beneficiaries? Well, I've alluded to it a couple of times. We have minor children. So that means we know we want to benefit our kids, but we know they're not ready to manage the assets themselves yet. At what age could they start to gain direct access? Who manages it before those ages? That's going to be the trustee that manages the inheritance. How are the assets divided and dispersed? Are there particular purposes they can withdraw funds for, particular amounts, or some combination thereof? When we get past the concept of restriction for a minor beneficiary, younger beneficiary, a trust can even provide a benefit if we have clients in their 80s whose children are in their 40s and 50s, and they say, well, we're not worried about restricting their access. Well, now the trust can shift gears and say, well, how about protecting the inheritance that they receive, protecting it from a lawsuit or a creditor liability, protecting it in the event of a divorce or other issue that comes up in the beneficiary's life. So a lot of flexibility in the design there. And then at the bottom, just kind of a high level statistic, take it for what it's worth. It's a statistic, so it's averaging out over large groups of people. But when they've studied this stuff, beneficiaries under the age of 35 typically spend an inheritance in 18 months on average. And that's regardless of the size of inheritance. So really important to understand for not just minor beneficiaries, but what we consider young adult beneficiaries, there can be a lot of risk to just giving them outright control of, especially of a substantial sum of money. So I alluded to it before. Final slide before I turn it over to questions is the concept of guardianship. This is just a real quick primer on if I'm naming guardians for my minor children, who might I consider naming and what types of factors might I consider? So obviously there's your typical where people's brains go, my parents, my siblings, family members. Keep in mind, it doesn't have to be a relative. It could be a friend or another couple that the family is close with, especially as the kids get to be the ages mine are in the middle school and into high school years. Geography can become really important, not uprooting the child from their school and their social circles. If my wife and I pass away, there's going to be enough that's been disrupted and uprooted in their lives, making sure we're cognizant of those dynamics. And then what types of things to consider? What are the potential guardians' values, parenting style? How stable are they both financially and relationally or interpersonally? What would their relationship be like with the child? What would their relationship be like with the trustee, which is just a real quick tease or alluding to the fact that the guardian who's caring for the children and the trustee who's managing the money, they could be the same person, but they don't have to be. And I might intentionally separate out those roles either due to who I deem to be the best fit in each role, or due to the fact that I just want some kind of separation of power between the person managing the kids, taking care of them, and the person in charge of the finances. But ultimately, it's what's important to you that goes into that guardian nomination. So I know that was a lot of me talking all in a row, which is just the nature of these virtual presentations, but I do want to now turn it over to the group and to some of the questions that have come in. And so what I'll do
All
here.
right, guys, thank you so much for your time and attention today. Obviously, if you have any additional questions or want to set up times you meet and start talking about the updates to your plan, contact Claire. I'm sure a lot of you
Hold on.
Claire and her emails down below.
I don't know what's going on here, so I'm going to stop sharing. So again, we really
All right.
appreciate taking the time here this evening to, oh my goodness, to get some of this information. Okay, hopefully that, apparently there was some audio on there, so you got to hear some old audio, but anyhow, I'll turn it over to Allison now for some of the questions that have come in.
Yeah, thank you, Peter. Very, very informative. And I have some questions from prior entries and then also questions during the presentation. And so first we have one during the presentation. Where and with whom should medical directive and will or trust documents be stored once they're created? Should these be shared with appointed guardians, medical doctors, or with whom?
Yeah, those are really good questions. So starting on the medical side, medical directives should be in all cases, in our mind, placed on file with your physician and regular clinic, ideally made a part of your medical record, whether copies are given, scans are uploaded electronically, etc. Simply because those are the documents that might be needed in an emergency, right? Those are the documents that we might not have time to get a hold of the attorney or figure out where they stored them at home or otherwise access them. And so I think it's important those are on file with your regular medical provider. For those and then all other estate planning documents, who you share those with and where you keep them is very much a matter of personal preference. My statement to all clients is make sure that the people you've named know that you've named them, whether that means giving them copies or simply telling them where the documents are, or for some clients, just telling them, hey, I've named you as a guardian, I've named you as a healthcare power of attorney. So that person is prepared in the event that something happens to me, that they're going to be on call. And also, frankly, to give them an opportunity to say, no, I don't want to do that, or ask questions that they would have about serving in those roles. I do always like to make the point that from an access perspective, people can get a little too concerned about privacy. Historically, you'd see clients putting estate planning documents in a safe deposit box and then realizing none of the kids know they have a safe deposit box at the bank or know how to access it or which branch location it's in. So to me, that's a little over the top. Keeping them at home, keeping them somewhere accessible is perfectly fine. And then making sure there are copies there at other locations in case documents get destroyed, right? Having your attorney will have copies on file. You'll have the original. Keeping electronic copies is an important way to make sure that you preserve the documents as well.
Great. Does a living trust need to file a tax return?
Great question, and an important one because it would be relevant to a lot of clients making the decision. The answer is no. A living trust doesn't file a separate tax return. From a technical perspective, that's because a living trust is a grantor trust, which means that it's a look-through entity from a tax perspective. So if my wife and I have a living trust, the tax identification number for that trust is going to be our social security numbers, meaning we're going to report all income on our ordinary tax return on a 1040. So there's no change in tax reporting if you do use a living trust.
Okay. Is it advised to have each spouse create their own will versus doing a joint will? And if you have a joint will and a spouse passes, does the remaining spouse, can they alter the original will if they wish?
So really good questions, and important to segment the terminology here. With a will, you actually can't draft a joint will. A will can only be an individual document. It cannot be jointly drafted by a married couple. And because of that, and because of another concept or legal doctrine out there, you actually can't restrict the surviving spouse what they can do with their will if I'm the first one to pass. There are statutes restricting the ability to enter into a contract to make a will, which is what that type of a restriction would be. And so if I have a will and I leave all the assets to my spouse or vice versa, I'm inherently taking the risk that they could change the terms of their will if I'm the first one to pass away, or them as to me if they were to pass away first. So a will is always an individual document. With a trust, not only can you draft a joint trust, but most married couples in Wisconsin do draft a joint trust, recognizing that we're a marital property state, that property ownership is shared and joint anyhow. Most clients are going to use a joint trust. And there, because the trust isn't a will and not governed by the will statutes, I can place restrictions through the trust concept if I were to pass away first on my surviving spouse or on anyone who were to inherit from me, simply by leveraging that concept that a beneficiary and trustee could be different, right? So I always use the example of if my wife died first, and that's because I'm able to then make myself the bad guy in the scenario, right? So the concept is if she passed away, she might want all the assets to benefit me, but she might want to make sure the assets that I received or inherited from her can only be used for me or our children, right? So she might set aside her share and say, it's okay for Peter to be the beneficiary, but I'm going to appoint a different trustee and I'm going to restrict his ability to change that share of the trust. And so you see that used all the time in blended families, but even in families where the children are both of the same marriage, it's easy enough for us to understand that, you know, if my wife died today, there's a reasonable possibility I get remarried. And if I do, does she want to make sure that I don't disinherit our kids or that I don't redirect those assets after her passing?
Mhm. That makes sense. Once your plan is in place, how often should you revisit it? Is this something that you would want to do like every year, every 5 years?
Yeah. So traditional wisdom would say 3 to 5 years is a reasonable time frame to review that plan. Now, my only problem with that time frame, or any time frame, frankly, is that the changes that are going to be relevant are only going to be known typically by the client themselves. In other words, your attorney's not going to know when you have a big blowout fight with your sister or brother, or when you have somebody who passes away in the family, or where there's a death, divorce, birth, or other family change. And most of the relevant changes are client-based, or family-based, or asset-based, which again, only the client knows about. So what we tell all of our clients is that we encourage you to review the terms of your plan annually. Now, that's not just sort of a business development tool here. That's not saying you have to meet with your attorney every year, and that's not saying there will be changes every year. But in any given year, enough can change that it's at least worth taking the time to review who I appointed as guardians, review who I appointed as beneficiaries and trustees and all these other roles. Again, it's an opportunity in my mind to reflect on what's changed in the last year while it's still fresh in our head, and then see how it impacts our plan.
Okay. And then finally, what would you recommend is the most cost-effective way to obtain legal documentation with our wishes for our children and our finances?
So that's a good question. Probably a little bit of a difficult one to answer, but I'll address it, and I'll also kind of share what I share with a lot of our clients is, when you're talking about what's the most cost-effective way, we first have to understand what are the goals, right? What are the goals, and what am I trying to accomplish here? Whether I'm looking at a will versus a trust, whether I'm looking at an attorney versus some kind of a do-it-yourself approach, I have to understand what my goals are and what I'm trying to accomplish to understand where the cost efficiencies and opportunities really are. This is comparable in my mind to a question we often get, or a statement we often get in a first meeting, which is, a vast majority of our clients will come in and say some combination of either my family is really simple, or my situation is really simple, or I just want a really simple plan. Now, some of them are just saying that because to them, everything about themselves is normal and simple because it's their own life. Some of them are saying it because they think that that's code for that they get to pay less if it's simple, right? But what I like to do with clients is reframe that and ask them when they want the plan to be simple. Do they want it to be simple for them to draft, and the time and effort and money they put into drafting the plan, or do they want it to be simple when the plan goes into action, when they pass away or when they become incapacitated? Because those are often going to be two very different plan types and two different sets of recommendations depending on what their goal is. And we have clients that fall in both categories. There are clients who say, well, no, I barely even want to be here talking to you. I want the simple work for myself, and everybody else can figure it out when I'm gone, which is fine. And then you have other clients who say, no, the only reason we're here is to make it simpler for those who come after us, or to make it simpler for our kids or our family members or loved ones.
Yeah. All right, great. I think that concludes our questions that we received, but again, we will include contact information for Peter in our follow-up email as well. So if you have additional questions or want to get a hold of his firm, we'll include that contact. So I just want to thank you so much, Peter, for your valuable time and sharing your expertise with us today.
You bet. I appreciate the invite, Allison, and I will just reiterate to the group, if you do have questions or if you do want to reach out separately, treat myself and our firm as a resource. We're happy to answer questions. We aren't your typical hourly billing law firm where you're going to be on the clock the second you email me. And we don't ever bill hourly for correspondence. So if you do have questions, my email will be in the contact information, our phone number. Please feel free to reach out and treat us as a resource.
Excellent. Thank you. And we appreciate all of you for joining us today. And we hope that you left with some valuable insights to help you in your own estate planning journey. So a couple of reminders real quick. Please remember to fill out the post-event survey that the friends will be emailing. And then also just a reminder about our next event, our family-friendly Earth Day celebration will be April 23rd at the Cottage Grove School Forest. And we hope to see you all there in person. And please tell your friends and neighbors as well. So I think that's all for today. Thank you all again so much. And we'll be in touch.
Thanks, everyone. Thanks, Allison.
Thanks. Bye.
Bye.